Please attend the court. The Honorable Court of Appeals of the State of New Mexico.
Please be seated, counsel, or get yourselves comfortable. Can we see both, counsel? Possible?
Right now it's on speaker view.
Uh-huh.
Whoever talks will show up on there.
Okay.
You can switch it to gallery view if you want.
Can we switch it to the other view? Thank you. Perfect. Thank you. Counsel, thank you for coming. Welcome to our very first virtual argument at the Court of Appeals. We appreciate you dealing with all of the emails that we keep sending you, instructing you on how we're going to handle this, and we hope that everything goes smoothly. I am Judge Vargas, and I'll be presiding over this proceeding, and the proceeding is Chandler versus Advanced New Mexico PAC Now, and J. McCluskey, A1CA 38649. With me here today also is Judge Megan Duffy, who's in the blue mask, and Judge Shamara Henderson, who is in the white and blue mask. Before we get started, there's a few things that I'd like to go over with all of you just regarding the proceedings today. First of all, I think that both of you know that this matter is being live streamed on YouTube so that the public can tune in and watch. In regards to how we will proceed today, because there are some delays and there are some issues of hearing each other sometimes in these virtual arguments, I would ask that the judges, when they're asking a question, please identify themselves as they're beginning their question.
Pause 1 second for the recording.
Sure. Just a moment, counsel. We're apparently addressing our very first technical issue, so.
So the FTR part.
Okay.
Of the Zoom.
Apparently we're having an issue with the FTR recording the proceeding, so please hang tight for just a second.
I have to make you a host.
Oof, thanks.
I'll quickly start here. Real quick.
Okay. Yes, we're all good to go?
Testing, 1, 2, 3.
Yes, okay, great. Thank you. Council, I'm sorry for the delay. Apparently we are now recording you and us. Back to some of the preliminary matters. I've asked the judges when they ask questions to please introduce themselves before they ask the question, because I know it's a little bit difficult for both of you to see who's asking the question behind our masks. Similarly for you, when it's your turn to talk, please unmute your computer, and when you're finished speaking, please remember to mute it again as we go through the proceedings. To accommodate the 1 to 2 second time delay that seems to happen between these proceedings, please wait until we have finished asking a question before you proceed with your answer, and we will try and do the same with you. Before we get started, I know Judge Henderson has a matter that she wanted to raise with council, and I'll let her address that and then let you respond to her.
This is Judge Henderson. Good afternoon, council. I just wanted to briefly address the fact that I'm sure both of you are aware that I am currently a political candidate. So in theory, there's a potential conflict with this case, being that it's in part about a political candidate. Obviously, my candidacy has no relevance into the candidacy of the candidate in this case. Different time period, nothing similar going on today. But I did want to raise it. Obviously, I'm here today, so I feel like I would be fair in this case. But with the theoretical, at least appearance of potential conflict, I did want to raise that before the parties and ask if that was fine with both parties before we move forward today.
First, Mr. Kennedy, do you have any concerns about Judge Henderson sitting on this matter? I think I need you to unmute, please.
So I'll mute it. Is he muted?
He does not appear to be muted.
But we cannot hear him.
Right.
Okay, you know.
Mr. Kennedy?
Can you hear me now?
Yes.
Yes.
Okay. I don't know what that problem was, because I showed myself as unmuted here. Regardless, thank you, Judge Henderson. I don't see that as an issue, and it certainly doesn't bother the appellants here. Well, we see no problem with it.
Thank you, Mr. Kennedy. Mr. Domenici?
Thank you, Judge Henderson, and we don't have any problem with you deciding this case.
Thank you, Mr. Domenici. So in light of that, we will proceed today. Mr. Kennedy, I understand you have asked to reserve 10 minutes for rebuttal. Is that correct?
Yes, Your Honor.
Okay. We're ready to have you proceed, but I will tell you that before you talk about the merits of the case, we would really like to have you discuss how this case falls within the parameters of the anti-SLAPP statute.
I understand that, and that was my intention too, to begin with that issue. So
Thank you.
So if it pleases the court, my name is Paul Kennedy. Seated to my right off camera is Ms. Jessica Hernandez, and we represent defendants, appellants here today. This case, of course, presents important and significant constitutional issues within the law of defamation. But I understand the court's concern with how we got here. And we got here quite legitimately pursuant to the anti-SLAPP statute, particularly section 38-2-9.1C. In other words, in the district court, we brought a special motion to dismiss. The district court ruled on the motion and denied the motion to dismiss without explicitly addressing the anti-SLAPP statute. And then we appealed this interlocutory appeal pursuant to 38-2-9.1C. So mechanically, that's how we got here. But how did we get here legitimately? And I think the court needs to look first at Cordova versus Klein, which is Justice Vigil's opinion in the Supreme Court, which is an extraordinarily broad opinion and interprets the anti-SLAPP statute in a very broad way to effect what Justice Vigil and the court felt were the legislative intent, was the legislative intent in passing that statute. And what the Supreme Court said was that in Cordova, that the statute is broad and covers speech outside a public hearing, so long as speech is made in connection with such a hearing. So it only has to be in connection with. What the court said was that phrasing revealed the legislature's intent to protect all activities, not all speech, all activity related to the public hearing before a tribunal. And even more significantly, what this court should consider is that in Cordova, there never was a public hearing. And the Supreme Court said, regardless, this statute still applies. So no.
But Mr. Kennedy, isn't it true that Cordova does still require that there be some speech or conduct that's in connection with some particular hearing, not just theoretically some hearing that may happen at some point in time?
Yes, I was just about to launch into it.
Great.
The first we contend, the first area of public hearings that we are in connection with are public hearings with state canvassing boards and county precinct boards in connection with each and every election. This, of course, was the June 2016 primary election. There were precinct boards appointed. There was a state canvassing board anticipated. And those, therefore, advertising during this political campaign necessarily entailed public hearings convened by tribunals and decision-making bodies such as these canvassing boards and precinct boards. So just by virtue of participating in an election, everyone who's participating is anticipating these canvassing boards and precinct boards.
Mr.
Now,
Kennedy, this is Judge Duffy. I reviewed the statutes that you had cited in the briefing regarding the election hearings. You cited 5 different provisions of the election code. I did not see in those statutes where we have a public hearing requirement similar to that of the recall petition in Cordova. Can you go a little further with your analysis into what portions of the election code require a public hearing?
well, the last time I remember participating in a state canvassing board, there was a public hearing. It was convened in the governor's office. The governor was present. The Chief Justice of the Supreme Court was present, and there's one other member that's I believe it's the Secretary of State was also present. That is a hearing. It's a quasi-judicial hearing, but it's a hearing, and that happens every election. One follows the other. First you have a campaign, then you have an election, then you have the canvassing board. And the canvassing board is a public hearing.
But where are we looking to in the election code for that proposition?
We probably didn't cite the statute, but my recollection is that there is a statute and or constitutional provision which requires the convening of the canvassing board. And it happens every 2 years. And so my contention is that our contention is that is a public hearing, and that anything you say in the campaign anticipates that canvassing board hearing. But even more significantly in that opinion, a court of opinion, here's what else the Supreme Court said regarding Cordova. Again, Cordova is the case where there was never even a public hearing. The court said the legislature intended to protect all public participation, whether it be in quasi-judicial proceedings or public hearings, reasoning that such interpretation comports with a national political ethos that encourages, promotes, and purports to protect citizens testifying, debating, complaining, campaigning, lobbying, litigating, appealing, demonstrating, and otherwise invoking the law on public issues.
But Mr. Kennedy, this is Judge Vargas, that law review article that's cited in Cordova talks about statutes that are much, much broader than our statutes, the California statute, and some of the other states that have grant many more rights, some of them including immunity, that our statute does not grant. How do we rely on that in deciding this case?
I think you go back to Cordova, and Cordova cites to those cases, does, I think, point out that they are different statutes, obviously, but the Cordova opinion is broader in the way it interprets our anti-SLAPP statute. Don't forget, Cordova itself never had a public hearing attached to it. One was anticipated, perhaps, theoretically, but it never had a public hearing attached to it. The court said that's just fine with us. The activities of those citizens are still protected. But,
Mr. Kennedy, this is Judge Duffy. In Cordova, we have participants who undertook all of the steps necessary to get before the court and then ended up dismissing the lawsuit on the courthouse steps as soon as the court convened the hearing. And what I'm wondering is, does our statute still require that the communication, the speech, or the conduct actually affects some participation in the quasi-judicial hearing or the public hearing that the statute is requiring here? So if we read it to require that the communication be in conjunction with participating, don't we need a greater nexus between a flyer that goes out to the electorate and a speculative hearing that happens at the canvassing board? Don't we need a greater connection there?
Well, with all due respect, Judge Duffy, I go back to the Cordova opinion. The Cordova opinion says explicitly that the statute is broad and covers speech outside a public hearing.
But it's related to Mr. Kennedy, this is Judge Vargas, but there has to be some sort of relationship to the public hearing between the speech and the conduct, doesn't there?
Of course. And that's why when a citizen participates in a political campaign, he's got a connection eventually to the canvassing board.
How does it, tell us a little, maybe we don't understand how canvassing boards work. How does the political mailer in this case affect a canvassing board or a hearing that a canvassing board might hold?
Because the citizen defendants here participating in the campaign anticipated that the plaintiff candidate here would either win or lose his election. And either way, whether it was a county canvassing board or the state canvassing board, either way, the issue of the election would end up in that hearing. But we don't have to rest on just the existence of elections and canvassing boards. We have prior litigation in this case that these flyers specifically addressed. This plaintiff filed litigation, and this court ruled in CYFD versus Scott C. Regarding CYFD's investigation of abuse on his ranch. That was the case in Zamora versus Chandler and Zamora versus Progressive. Also in this court, Chandler, the plaintiff here, was sued for wrongful death, negligent hiring, and the death of a child on the ranch. The case of Quevedo, the Quevedo opinion, which I cited in the briefs, was issued by this court just after this primary election. But details in this court's opinion details what was going on exactly when this litigation was occurring and exactly when the primary election campaign was occurring.
Mr. Kennedy, this is Judge Duffy. For our record here, I want to clarify that the CYFD versus Scott C case was decided prior to the mailer and cert had been denied prior to the mailer, correct?
Yes.
And in the Quevedo case, Mr. Chandler was not a party, is that correct?
I think you're right. Yes.
So the only case that we have pending at the time that the mailer goes out is Zamora versus Chandler, by my reading of your brief, is that correct?
That's probably accurate, but I would urge upon the court, again, you have to look at it under Cordova, and it doesn't matter the timing of the cases. What matters is, were there statements made in connection with the cases? And I go right to Plaintiff's Exhibit C, right above the complaint of a quotation. Parents are suing Scott Chandler for abusing children on his ranch. Now that's legitimate commentary on litigation emanating from this court and other courts and made in connection with that litigation.
But that's not any of the statements that are that are being challenged by Mr. Chandler in this case as possibly defamatory. So that's not really before the court at this time.
Well, again, with all due respect, I think you're taking the court's question implies a very narrow view of these mailers, these exhibits, and a narrow view of legitimate commentary that these defendants have a right to make in the course of this campaign. And if it's in connection with the litigation, connects somehow with the litigation, it doesn't have to be within the litigation. It can be far outside the litigation, according to Cordova. Then we would suggest that we fit within the anti-SLAPP statute for these jurisdictional purposes.
Looking at, pardon me, Judge Henderson has a question.
Mr. Kennedy, this is Judge Henderson. My question in regard to, it doesn't matter whether it's prior litigation, current litigation, or potential future or known future litigation. And I understand what you're saying about Cordova saying that it's all activities outside of or could be outside of the public hearing. But again, in that situation, there was pending anticipated litigation. If you look at some cases from Nevada, Patton v. Ton Van Lee, Massachusetts, California, all of them discuss the idea that there's some at least anticipation of an actual hearing, public hearing, or tribunal in this. and as a forward future opportunity. So I'm wondering how it applies to prior cases and how Cordova actually anticipated that.
Well, again, I would argue that he made a statement in connection with prior cases and in connection with a pending case, the Quevedo decision. Again, under Cordova, it's commentary outside the hearing, outside the tribunal, but it's political First Amendment free speech activity in connection with these pieces of litigation. And so again, under Cordova, you have to read the statute broadly. Cordova itself is very broad, and I would urge upon the court that the connection, statements made in connection with the litigation, bring us within the anti-SLAPP statute. And then we have a third basis.
Justice Kennedy, this is Judge Duffy. Under your reading of the SLAPP statute, if we were to adopt that broad reading of the SLAPP statute, does that mean that any speech or conduct that cites to any past court case, any future court case, is suddenly under the umbrella of the anti-SLAPP statute? Doesn't that just open the door to all speech within our anti-SLAPP statute?
Well, there has to be some connection. No, in other words, if the defendants here had made a comment about Miranda versus Arizona, had no connection with this plaintiff or with the political campaign or anything like that, but that's not in connection with. But if the defendants here make explicit comment based upon a pending litigation or past litigation that specifically involves this plaintiff, then that's in connection with, I would argue to the court.
How do you reconcile, sorry, pardon my interruption, Justice Kennedy, Section 9.2, the findings and purpose of our anti-SLAPP statute, where the legislature wrote that one of the reasons it's adopting anti-SLAPP in New Mexico is because lawsuits have been filed against persons for exercising their right to petition and to participate. And so we are looking at this direct connection by the person engaging in the conduct or making the speech, then participating or petitioning. So we have this direct connection by the actor making the speech. Is it your position that we have that direct connection here, or was the speech made for the purpose of entering into the lawsuit or the canvassing board or future legislation? Those are the three examples you cited in your brief.
Well, but again, the statements only have to be in connection with those three items. They don't have to be part of that hearing. And Cordova makes that just explicitly clear, that speech outside those tribunals still counts as protected speech under the anti-SLAPP statute and gives this defendant those procedural rights under anti-SLAPP.
But Justice Kennedy, in Cordova, the persons who undertook the speech and the conduct were the ones who ended up participating. They were the ones that petitioned for the hearing. We don't have that direct connection here. From your briefing, we haven't seen anything from your clients actually participating in a petitioning activity or participating in the underlying subject matter. And so we have a more indirect connection here. And so that's the gap that we're trying to cross.
Well, I think you're seeing a gap there that doesn't exist under Cordova. And again, I mean, it's a legitimate point of view, but the problem plaintiff has here is that Cordova speaks directly to this. And all Cordova says is, you don't have to have a direct connection. It just has to be, it's all speech. And actually, it says activities outside a public hearing, so long as the speech is made in connection with such a hearing. It doesn't say it has to be a strong connection or a close connection, it just has to be some connection. And I would suggest if this court goes down that path, it would be contrary to Cordova.
But Justice Kennedy, this is Judge Vargas. In paragraph 21 of Cordova, Justice Vigil says, we are also persuaded that the phrase in connection with in section 38-2-9.1a, I'll let you catch up before I go on.
Was that paragraph 21, Judge?
It's paragraph 21, it's toward the bottom.
Okay.
We are also persuaded that the phrase "in connection with" in section 38-2-9.1A reveals the legislature's intent to protect all activities related to the public hearing before a tribunal. So Justice Vigil seems to be limiting the conduct and the speech that's being referenced in 9.1 to activities related to the public hearing that we're talking about. So I share Judge Duffy's concern that there's a gap between what the hearing is and what the conduct and speech that we're talking about today is and how they're related to each other.
I understand. I just go back to the Supreme Court's citation to the Pring and Canaan Law Review article, which says that it comports with a national political ethos that protects, among other things, campaigning, lobbying, litigating, debating. So obviously, the Supreme Court saw much broader than this court appears to today. And we'd urge the court to find that there's minimally the jurisdiction so that we can consider at some point substantive issues. Thank you.
Thank you, Justice Kennedy. If you'll mute your microphone. Is he muted? Sounds like he is.
Yes.
Mr. Domenici, we would also like you, I'm sure you've guessed by now, to discuss the SLAPP statute.
We filed a motion to dismiss the appeal, which is in the record, because we were concerned that the anti-SLAPP statute does not apply to this case, but it was providing for an expedited appeal that otherwise would not be allowed. And we contended, actually our arguments were fairly close to what some of the questions we've just heard. We contended that both the purpose and the language of our anti-SLAPP statute should not be expanded to be virtually unlimited.
Well,
Mr.
Domenici, this is Judge
Yes.
Vargas. I do, in Cordova versus Klein, the Supreme Court does seem to be adopting a very expansive, broad interpretation of our SLAPP statute. Why should we not follow that broad interpretation down the path that Justice Vigil seems to be leading us down?
Well, I don't think the statute allows it, frankly. I think that's a single case. I think it clearly applied in that case because there were petitioners on the eve of or maybe even starting a court hearing. So that clearly applies to that circumstance. I think to take what would otherwise be dicta out of that case and say, if you were in an election, and you happen to mention some lawsuit that you had no connection to as the party presenting the campaign mailer in this case or some other circumstance. And when I say connection, I mean in the common sense of connection. I don't mean in some strained idea of connection in that we live in the same state and we heard about this case, or we're in a case that actually refers to another case, even though we had absolutely no participation in that case and never intended to participate in that case and never can because the case is closed. So I don't think it's intended to, if you look at the statute, even reading it with Cordova, the Cordova decision, I don't think it's intended to be that as broad as it is in this case. It does place an excessive burden on the plaintiff. We succeeded on a motion to dismiss and we're ready to move forward, and then we have to stop essentially and have an appeal heard simply because they allege the anti-SLAPP statute. They didn't even argue it to the district court. In their reply brief, they said, we're not going to argue anti-SLAPP, except we may use it in the case for an expedited appeal. or
Well,
a
Mr.
claim for attorney's fees.
Below, did you ask the court to enter any sort of an order or ruling on whether anti-SLAPP applied or not?
No, it was not discussed at the hearing. To my recollection, after the defendants said they were not seeking a ruling on it, we did argue in our briefs, but the way that case was handled is we had oral argument, very limited questions, and then the court took the case under advisement and issued her own order, as you've seen. So she didn't, file an opinion and ask the parties to draft an order or anything like that. So she chose.
And you didn't ask the court to find that there was no anti-SLAPP case here?
We asked them to deny their motion setting forth the anti-SLAPP claim as grounds for dismissal, but at the close of the hearing, we did not ask for a specific ruling on the SLAPP statute. That's correct.
What about the defendant's appellant's argument that this case has all of the traditional indicia of a SLAPP suit, that it names John Doe's, that it asks for lots of money, that it has defamation claims? Why shouldn't we look at those things and say, looks like a duck, quacks like a duck? We've got an anti-SLAPP. This is not an anti-SLAPP.
Your Honor, the claim for relief in the complaint asks for compensatory damages as established by the court, and it asks for punitive damages. There's no dollars requested. The reason we entered John Doe's was because, and now we've sort of seen some of that coming around, we expect that there were consultants or contractors working on these mailers. They've even indicated, really without citing the record, that a graphic designer was hired. I don't know if that was meant to be hypothetical or not. It makes it sound like it's pretty true. So at the time we filed, we were of the opinion that there was an additional entity, not many people or unknown people, but someone who did the research that went into these mailers, who did what is called in political world opposition research. So we had no opportunity to know who those were. We didn't know if the defendants might, for example, blame them or try to push the case in their direction. So as an abundance of caution, we joined them. I don't think it has any of the other indicia of a SLAPP suit. It's a set of mailers that are fairly astonishing in their content. There is, and there's no request for massive damages. That's simply a misreading of our complaint. There's just simply nothing to support that. And the John Doe's are as I explained.
So going back to the anti-SLAPP statute and the in connection with language, how should we decide if the conduct or speech that comes before us is in connection with a public hearing meeting?
I would think it would need to be in the context of connection in terms of participating in that public hearing or quasi-judicial or public meeting or quasi-judicial public hearing. It could also be preparing to participate or aiding in participation, which I think would capture some of what Justice Vihil's concerned about perhaps, but I don't think it means after the fact simply referring to something means you have the protections of the anti-SLAPP statute when you didn't participate in any of that conduct.
Good afternoon, Mr. Domenici. This is Judge Duffy. Couldn't the flyer be construed in a way where it's providing notice of a public hearing that's ongoing and notifying the citizenry since Mr. Chandler has undertaken to make himself a public candidate? Is the perhaps notice component of the mailer enough to bring it under the umbrella of SLAPP?
I'm not sure what hearing you're referring to.
Justice Kennedy, was pointing out some of the ongoing lawsuits that Mr. Chandler was involved in around the time that the mailer went out. And that's what I was referring to.
Okay. Well, I don't think providing notice of a lawsuit that you're not participating or aiding or somehow associated with in any way should be protected by the anti-SLAPP statute. This is to protect political participation in whatever hearing it might be. The canvass board would not have anything to do with this mailer. It wouldn't be considered. They would be judging voting is all that they would be looking at. So this would not provide any notice that would provide any benefit to anyone about a canvassing board hearing.
Mr. Domenici, this is Judge Henderson. My question to you is, how do you respond to the piece in Cordova where it says it does protect all activities related to a public hearing, whereas other states have seemed to have narrowed what that means a little bit more, whether it's, information related to substantive issues and it has to be directed at a party or a person that's relevant to that litigation or a public hearing, or in a way that's going to be directed towards the government agency with the idea that they would receive notice. Our case law seems to be much broader than that.
Well, if I understood your quote, it was activities related is what you quoted. So I don't think this activity of presenting this mailer, distributing it to all of these potential voters is an activity related to prior lawsuits. I don't think the statement was correct that there was a pending lawsuit. The pending lawsuit I understood at the time was Zamora versus Progressive, which was an insurance coverage dispute that came out of the auto accident. But to my knowledge, everything else had been resolved by 2016, all of the cases that were cited. So I don't really see how this is an activity related to a hearing.
So, Mr. Domenici, I want to talk a minute about the defendant's claim that there was legislation that had been proposed before, and that's one of the proceedings that this mailer might be in connection with. As I understand it, the legislation was introduced, or one form of legislation was introduced in 2014, then it was reintroduced, or another version was reintroduced in 2015. It's kind of unclear as to whether it was introduced again after that. If there was a plan or an intent to introduce similar legislation that your client had opposed in, say, 2016 or 2017, would that be enough to be in connection with the proceeding that would bring this within the anti-SLAPP statute?
Possibly, given Justice Vihil's language. There's no evidence that there was any activity in 2016 or anything planned for 2017.
But that you
But
think
if there
that
was
might be
something, if there
enough?
was something relatively imminent, then possibly it could.
Okay.
Mr. Domenici, this is Judge Henderson. Do you think that there needs to be an intent requirement?
I'm not quite clear on that question, Your Honor. Could you?
I'll
Put it in
rephrase.
context.
So we're looking at kind of the actions that have been taking place in Cordova and some of the other cases that were cited in both briefs. Some states look at a little bit more of the intent of the party when they engaged in that action, whether or not there was an intent for some type of future public hearing in terms of what their intent was to petition the government. Do you think that there should be any form of an intent requirement to be shown, like the mailers were intended for a future public legislative hearing, or there was intent to affect what the pending case?
Yes.
What should that intent requirement be? How should that look?
I think it should be very simple. There should be something imminent or pending that the mailers actually go to the issues in that pending matter, or planned, not just speculated, but actually planned, which means a plan is in place that would satisfy the intent. I don't think, frankly, I don't think going to a litigation that is and doesn't involve the defendants in the case, and they have not participated in, they're not parties in, they've had no involvement in, then I think that's quite a stretch. I think the lobbying one is a more realistic scenario, because they talk about public meetings, they talk about administrative boards, including state entities. But I think the lawsuit is very much too broad to say if there happens to be a lawsuit that ever occurred related to this case, then it's connected because we mentioned the lawsuit. So I think there has to be an intent to actually participate or somehow engage in the proceeding, which I think is quite difficult for a lawsuit that you're not a participant in, and particularly if it's a closed lawsuit or dismissed lawsuit. So I don't think that's pertinent to this case, and I don't think there's evidence of any lobbying planned or that occurred, or that it occurred even in the session that year.
Thank you. Just for the record, I was referring to, it's a Massachusetts case that has an intent standard, Blanchard v. Stewart Carney, and it talks about this intent to influence is manifested in statements that are closely and rationally related to the government proceeding and in the furtherance of the objective served by governmental consideration. And that was why I was asking whether or not we thought that there should be an intent requirement, which isn't clear from Cordova that there is.
Thank you. Can I proceed with my argument, or may it please the court?
Please do, Mr. Domenici.
So,
Thank you.
I'd like to sort of tie this this briefing that we have to the anti-SLAPP issue. And I would start out by saying this is an extremely ambitious amount of material to cover in a motion to dismiss in a case where there's been no discovery. And one of the ways I would point that out is to refer the judges to the index in the brief in chief, which indexes what the argument is, and it also discusses some of the authorities. And in just sort of slowly going through that, I think it's before we go through that, actually, I think it's important to identify where this House Representative seat is. It covers all of Luna County, virtually all of Hidalgo County, and a tiny sliver of Grant County, which goes down to Hachita on the border. The cities or towns, if you will, in this district are Deming, Lordsburg, Hachita, Rodeo, Animas, and Columbus. And so I would just, as an initial point, indicate that there's been no connection with any of the alleged media that might have harmed my client's reputation with any of these communities. So there, as an example, there's a reference to a New York Times article. Well, I think for that to have any effect on this decision, there would need to be some connection established that people in these communities, and Mr. Chandler has lived in Deming for 42 years, but also these other towns are fairly close by. They're part of the same community in the sense of at least the representative district. There's been no showing that, and I don't think it'd be very hard to show, but maybe they could try, that any of those articles or news presentations had any effect whatsoever on Mr. Chandler's reputation. So when I say this is an ambitious filing, I would point out also, and I would anticipate your clerks have told you this, but on the section of media on page 9, my calculation is there are 5 new media stories that were not mentioned at all in the case below. They were put in the brief in chief essentially as new evidence for the first time. And then they're referred to constantly to try to make this argument that my client's reputation has been harmed. So that is, why I say this is really ambitious, to think that those articles could destroy someone's reputation so much that it can't be destroyed any further. And there's no connection with any of those with any of the people in his community. There's not even a statement that the Albuquerque Journal is distributed in Demi, which it is not. So not only do we have sort of this ambitious effort to add a bunch of essentially evidence to this appeal brief, but then we have this, again, very ambitious effort to connect that and make these very significant conclusions, and they're disputed right in the complaint. In the complaint in paragraph 18, we state we had an agreement to operate in early 2014 with CYFD. That totally contradicts the idea that Mr. Chandler's reputation was somehow so destroyed, or his credibility was so low that he couldn't reach an agreement with the regulating entity. And then in 2017, that same agreement with some changes was made permanent. And that's in the complaint and should be accepted as true. In addition, Mr. McCleskey stated in the attachment that Mr. Chandler was clearly winning this primary. That completely contradicts the idea that his reputation was already harmed to some significant extent. So, and a lot of the brief goes to that basic idea that we can't hurt his reputation anymore. You can't prove we hurt it anymore, that he's what we call libel proof. And I would also point to the court that the libel proof doctrine was not raised below. And particularly the sort of more refined versions of that. One is called the incremental approach, which says, your reputation is so harmed, you can't be harmed incrementally anymore. Based on these newspaper articles and these TV reports that are not connected at all to the community. And the other one is a specific issue, form of libel proof. Again, that wasn't even raised in the trial court. So I'm not sure, we're really dealing with an appeal that is de novo, or like which means the trial court doesn't get deference. I think we're actually dealing with a whole set of new circumstances presented for the first time to the Court of Appeals under an expedited appeal under the anti-SLAPP statute. And I think that is entirely too ambitious to try to use those very disjointed facts, possibly inadmissible facts, to create any kind of determination adverse to my client. And then I'd like to just go to the mailers. So there's 2 mailers, and one of them is, I would call, the government oversight mailer, and that's what the defendants called that in their briefing. Well, simply looking at the first page of that has both police tape and then how did a business accused of child abuse and torture avoid government oversight? Just looking at that alone, you see 2 factual statements. And I know that there's some argument that a question can never be defamatory, although in that same case, the author cites a treatise that says questions can be false if they have a statement embedded in the question. And that case is the Abbas case, and Abbas was cited in the to the Young versus Wilhelm case, it actually cites Abbas, and it cites it for the proposition that you have to look carefully as to whether a question is actually a statement or an opinion. So our courts have already decided that it's not universal, that just because you put a question mark and you put a how in front of a statement, that that's not a statement that can then be proved factual. And in fact, the other key piece to look at is, there's two key pieces. So first of all, would a reasonable person think that that is a statement of fact? And I think absolutely the trial court ruled that the reasonable person could easily do that. And I think that's absolutely true. You read that statement, and it is telling you that a business accused of child abuse and torture avoided government oversight. And then the police lines are the other one that are right on the face of that, and that is a factual statement. They try to, I know the defendants try to say it's a caricature or something like that, which really doesn't fit at all, particularly given the statement right above it. So on its face, there's two factual statements here. They're not opinions. They can both be proven factually to be true or false, which is what the trial court ruled on both of these. Now, one of the other issues that's come up is that because they don't mention Scott Chandler on this, and that this isn't about him. Well, we actually have a jury instruction directly on point with that, which is 13-1005, describes whether or not a defamatory statement concerns the plaintiff. And that reads almost verbatim what the trial court used, and she pulled her definition out of the restatement. But the UJI says the communication must be concerning the plaintiff. The communication is concerning the plaintiff if the person to whom communicated reasonably understood it was intended to refer to the plaintiff. So if you look at the top of the second page, which would be the back page of the mailer, it specifically talks about Scott Chandler in bold. It talks about Scott Chandler in the box to the right. It talks Scott Chandler in the box to the bottom. So that argument they make for all three statements, and I think it's really a loser on all of them, because they intended these to impact people who are going to be voting for Scott Chandler, and they made it very clear these were about Scott Chandler. So that's a couple of the arguments that we really see problems with. I would also say something that's very important with respect to the government oversight mailer. If for any reason the court feels it needs to go beyond looking at that language to determine whether it's a factual statement or an opinion, which I think the Amber case clearly says that's what's to be done. And then in Marchiando, they say the same thing. And really the key thing is whether a reasonably prudent person would consider the publication a statement of fact or opinion. So, but if you happen to go beyond that, there is a key timeline and timing issue to all of this. The Cavato lawsuit alleged claims that did not involve any of the youths that were at the facility in 2013. None of the youths in Cavato were at the facility in 2013. They were there in 2011, some of 2012, 2010, 2009. And then none of the youths that were there in 2013 ever filed a lawsuit. There was a wrongful death rollover accident by someone who was over 18, but there was no claims of abuse by any of the youths under 18. So to argue that the discussing lobbying in 2014 and 15 as justification or as an explanation as to how Mr. Chandler avoided government oversight doesn't meet the criteria for, in some cases where an opinion could be perhaps established or at least looked at because there is some supporting information.
Mr. Domenici?
Yes.
This is Judge Duffy. And I think we're faced with a little bit of a chicken and the egg problem in terms of our SLAPP statute, because as I read it, it's designed to allow litigants to get before the court procedurally very early on to determine whether or not the lawsuit is in fact a SLAPP suit. And you have the district judge looking to pierce those allegations and find out what is the real purpose of this lawsuit. So in a way, we're faced with the situation where we don't know if it's a SLAPP suit until after the district judge has already done their review and taken a look at it. So how, as a practical matter, is a district judge supposed to determine when presented with a SLAPP motion whether we're actually dealing with a SLAPP case in advance of actually hearing it, and after the judge has heard it, how do we determine whether or not we're dealing with a SLAPP case that is immediately appealable?
Well, I think one of the questions to me was, did we ask for a specific ruling on the SLAPP? And I told you we didn't, but I think if you want to remand it and we have oral argument or however the remand reads, have the district court rule on that. I don't think she felt she needed to rule on it based on the way the hearing was structured. There was no discussion of it at the hearing. It was mentioned in the brief that they weren't even asking for a ruling, really, only maybe perhaps to use it for an expedited appeal. So
well, the only thing I saw in the order was that she left open the question of attorney's fees, and my understanding is the only basis where those would be allowed is if this was a SLAPP suit within the statute.
That may be true. I mean, I know we could be entitled to attorney's fees under the SLAPP statute if the SLAPP claim is frivolous. So I think she left open the possibility that at some point we could claim the SLAPP piece of this lawsuit was frivolous and claim our attorney's fees. That's how I read that in light of the ruling she made on the substantive issues of the motion to dismiss, which really went to the defamation claims and the various mailers and all of that. So I read that as saying, if you want to come back and request fees, you may, because you may be eligible for I'm paraphrasing, but it's essentially a frivolous SLAPP lawsuit. So I wouldn't read too much into that. I would be careful to read that she thought there was a SLAPP lawsuit. I mean, I think she would have said so if she thought there was one, and would have certified it for appeal and everything. But she didn't do any of that. I see my time is up, but that's my answer to that question, Your Honor.
Thank you very much, Mr. Domenici. I appreciate it.
Thank you, Mr. Domenici. Justice Kennedy, you've reserved 10 minutes.
I think it's clear, just from that argument you just heard, let alone the pleadings in the case briefing, that this is, as I think Judge Duffy put it, this has all the indicias of a SLAPP suit, in that this is what's going on here is this is a grudge lawsuit. The plaintiff here lost his election. He blames my clients for having lost the election. He doesn't blame himself. He doesn't blame himself. His reputation was ruined. He doesn't blame himself that he was involved in all this litigation. He doesn't blame himself that he lobbied against a regulation for his ranch in the legislature. He blames my client. And so what he's doing here is he's imposing extraordinarily expensive legal fees on our clients in order to exact some punishment for what he sees as their involvement in his loss of the election. That's
Justice Kennedy, can I ask, what is the effect of the plaintiff's failure to get a ruling below on whether this is an anti-SLAPP statute or not?
Well, I think they've waived any argument on that. To be clear, my recollection is that we clearly invoked the anti-SLAPP statute in our motion. and our filing. And in fact, Judge Delaney gave us an expedited hearing on our 12B6 motion in accordance with what the statute requires. When we got to the hearing, we had extended argument, but the plaintiff never broached the issue of the anti-SLAPP statute, nor broached any issue as to whether an expedited hearing on the 12B6 was appropriate under the statute. So to that extent, I think they've waived those arguments. But of course, as we know, jurisdiction is always a matter reserved to the court in the last instance. And so I don't think they probably waived arguments that they could have made below, but that I don't think it removes the issue. In their briefing in this court, they said they think the issue is moot because after all, here we are. Well, that doesn't really solve any jurisdictional issue. And the issue for this court is whether you have a legitimate interlocutory appeal in front of you pursuant to the statute, or whether the interlocutory appeal is inappropriate because it falls outside the statute. And that's really the issue. So I don't think you can really waive that. I think they probably waived their arguments, but again, it doesn't take the issue from the court. So I think, again, the effect of this litigation is it's a strategic lawsuit against the defendant's participation in the election. There's no doubt about that. Contrary to what counsel says, there's no requirement that you have to be aiding in preparation for a hearing or preparing for a hearing. Cordova clearly said that if it's speech outside the hearing, outside the tribunal, it still comes within the anti-SLAPP statute. And again, I emphasize, there never was a hearing. And the court found that's just fine. This statute applies anyway. We go back to that.
So Justice Kennedy, this is Judge Henderson. I just wanted to ask you the same question quickly that I asked Mr. Domenici is, so do you believe that in Cordova there is any kind of intent requirement that you see in some of the other districts or jurisdictions?
Intent on whose part, Judge?
The intent of the party in terms of that they are petitioning a government agency or they're intending to influence some type of judicial proceeding?
Well, I don't see that in the statute, and I don't see it in Cordova. I think if the intent is, for instance, if the intent is that we have to defeat this guy in the election because if he gets into the House of Representatives, he's going to kill this legislation that he lobbied against. Now he clearly lobbied against the legislation. The legislation was clearly before the House and the Senate. And if the intent is to make sure he doesn't get on the inside to kill this legislation forever, then I think that would satisfy any intent requirement, Judge, that you might read into that statute. But I don't see it in Cordova, and I don't see it explicitly in the statute. So I guess my basic answer would be no, but that you could easily find intent here in under this particular set of facts. The argument from counsel that, well, there's no connection between the New York Times and Deming and Lordsburg, I think, number one, it's an absurd argument, but also I would remind this court that New York Times versus Sullivan came out of a small town in Alabama, all the way to the United States Supreme Court. And the argument at one point in Sullivan, the argument was, well, there really wasn't much connection to the New York Times and rural Alabama, and we see where that argument got them. And in terms of the substance, I won't particularly address the substance because obviously the court's interested in the jurisdictional issue. But I would suggest to the court that our substantive arguments are very strong. We are where we are. We're here. If you're going to get past the jurisdictional issue and allow us in, I would urge the court to take a close look at our arguments on the substance. None of these statements were about the plaintiff. They were carefully phrased to eliminate the plaintiff or make sure that he wasn't explicitly named. They're not about him. He feels offended because of his legal situation. So I'd ask the court to take a close look at our substantive arguments if you get that far. Thank you.
Justice Kennedy, I have one more question before you leave us, if you don't mind. So you mentioned that, you know, in response to Judge Henderson's question about intent, that one possible intent would be to keep him out of the house so that he can't kill the legislation that we've been talking about from the inside. Was that the purpose behind these mailers? Is there something out there that says this is why we're advocating against him?
Well, I don't think there's anything out there. I think it's clear that his successful opponent in that campaign opposed him partially because of his these sordid activities that he was participating in over the years. And there's no question that the controversy and the litigation and the child abuse that this plaintiff participated in was an issue in the campaign, and his primary opponent had every belief that if he got if he was successful and entered the House, that he would aggressively try to kill any legislation, just like he aggressively tried to do it while he was lobbying. And so clearly these are all issues in the campaign. And again, judges, when you get involved in in a First Amendment situation, the First Amendment's as broad as all outdoors in this country, and as is this anti-SLAPP statute, as Cordova opinion. And so when we start discussing these issues, when we debate, for example, whether the primary opponent had this issue or whether the primary opponent had this feeling or intent or whatever, you've answered the question. It's political speech. He's immune from political speech. It's the highest level of speech and the highest level of protection our Constitution gives to speech in this country, political speech during a political campaign. That's exactly what we have here. So I would urge on the court a close look at the statute in Cordova and a ruling, a holding that says that indeed we've come within the boundaries of the anti-SLAPP statute. I'll sit down if you have no other questions.
Thank you very much. Justice Kennedy, Mr. Domenici, thank you very much for your very well thought out and very well argued cases. The court's going to take this case under advisement and we will issue an opinion forthwith. Thank you so much. We appreciate you participating in our first virtual argument and being patient with us.
Thank you.
Thank you. We are off the record. I guess I can't do that.